We give you 4 possibilities, A, B, C, or D, but only one, and always one, will be correct, yeah? Which makes it a bit easier for you when compared with the second possibility. We could also create an exam where 0, 1, 2, 3, or 4 possibilities are correct, but to make it more comfortable for you, we offer this version where only one and always one is correct. There is a time limit, 40 minutes. Usually, if you will be present in a class, in a classroom here, so it's closed book exam. However, we don't know how the pandemics will develop and the situation. So we are also prepared also to give the exam online, but you will be informed in advance when we will have the final decision. Yeah, it's still not decided. At the moment, it seems that we will have face-to-face examination in classroom. You will be sitting here for 40 minutes with closed books and so on, and you will just go through the questions on multiple choice. Now it seems that the stream is on. Yeah, now it seems that the stream is really on. So just let me for our viewers on YouTube, just let me shortly recapitulate that this is the shape of the exam, and just shortly you need to be logged in information system, and in the subjects column here, I will try to go back shortly. Yes, when you are logged in information system, you see the subjects here. You go My Courses, and in private law, if you click private law, then you see files prepared for you to be downloaded, supportive material for study, and here is also the place where PowerPoints from lectures will be uploaded, including this PowerPoint, including this one. Just shortly, how to study. Yeah? We don't prepare the exam in a way like let us know what is on page 70 of the supportive material number 1. Yeah? We always, during the exam, focus on topics which were expressly mentioned, which were expressly discussed, expressly exercised during lectures. Yeah? So to be well prepared for the exam means go and visit our lectures, plus repeat from PowerPoints, which will be uploaded. Yeah? This is your study material number 1. Your supportive material number 2, if you want more information, is the reader from 2015, this one, because it's about new civil code, so it's good supportive material. And only in case you need more information concerning more general topics like principles of private law, like persons in law and so on, you can use the material, the file from Dr. Hrstkova. However, always compare and contrast with actual civil code. Yeah? So if you are regularly present during lectures, if you are working, then with PowerPoints for kind of repetition, you are able to pass the exam, and you are able to pass the exam with a quite good grades. Yeah. So don't be afraid of the exam in general. Yeah? Important thing, if you obtain, let's say, B or C, no retake is possible. The retake is possible only for students awarded with F or FX grade. Yeah? So keep this in mind. Yeah? Fine. And at the beginning, email again for students on a stream. You see an email. Don't hesitate to write me an email if you have some questions concerning the organization of the course. Yeah? And today I have somehow to introduce the private law in Czech Republic to you. I have shortly to lead you into the problem. Yeah? So we will make a short journey through history. It's important and necessary, but it will be the only speaking about history. There will be no more history then later. Yeah? It's always on me to be the bad one who feeds you with history. However, you need to have a broader context of a private law in Czech Republic, and I will make really important points from history of Czech Republic and the development of private law. What you see here is a map. It is a map from year 1919. Yeah? Quite an old map, and it shows newly created states when Austro-Hungarian Empire collapsed. Yeah? After the collapse of Austro-Hungarian Empire, you see newly created Austria, Hungary, Romania in a new shape, Yugoslavia, Italy in a new shape, you see Poland in a new shape, and you see what we are interested in, you see the Czechoslovakia, the Republic of Czechoslovakia. We were, or the country was, before the Czechoslovakia was created, we were the part of Austro-Hungarian Empire, which means, from the point of private law, that we were using the General Civil Code from 1811. Yeah? Before we had our state, our republic, we were the part of Austro-Hungarian Empire, and the private law here in force was General Civil Code. Yeah? Here you see the date, including the day and the month of creating Czechoslovakia. That's the day when Czechoslovakia as a new independent state was created. 28th of October 1918. You see it's in October, it's a state holiday still today, so the Republic will have anniversary. In short, so it's the state holiday. Yeah? And what does this mean for the development of private law in our country? The development concerning the collapse of the empire and the creation of a new state, it was so fast that there was not time to prepare a new legal system for the new republic. Yeah? So what we have done is there was adopted so-called Reception Act. Yeah? Number 18/1918, number 11/1918, a collection of laws. And In this Reception Act, it's a strange name, I will explain. In this Reception Act, we simply have enacted that we will continue in using the General Civil Code. In fact, we will continue in using the whole legal system of Austro-Hungarian Empire. Yeah? And then later we will prepare our own Czechoslovak legal system. Yeah? But in the first moment when the Republic was created, we were simply continuing to use the legal system of Austro-Hungarian Empire, which means including the General Civil Code in private law. However, there is a situation which, as a result, there was a situation which you can see quite exceptionally. It's very rare to happen this, but here it happened. The point is that the General Civil Code was used in the Austrian part of the monarchy, which means this part was the Austrian part. Yeah? However, this was the Hungarian part, and in the Hungarian part, the General Civil Code was not in force. Yeah? Private law in the Hungarian part of the empire was composed mostly of legal customs. Yeah? And if we said, okay, we will continue in using the legal system of Austro-Hungarian Empire, it means that you have one state, yeah, you see it's a united state, one state, but here is the line approximately, and here you have General Civil Code in force, and here you have legal customs in private law in force, yeah, and not General Civil Code. Yeah? So it's a really rare and strange situation where you have in one state, one united state, you have two legal systems in force. Yeah? Which is obviously a situation which shall be somehow solved. Because it's not very useful to have one state and inside to have two parts, two systems of private law. So it was clear that we will need a new civil code. Yeah? This new civil code was prepared. Here we have that the draft was finished in 1937. However, this draft has never been adopted because of the Second World War. Yeah? And in a few moments I will show you why it was important to mention that we had a draft for a new civil code prepared. Then after Second World War, what happened later, after 1948, the Communist Party took the powers in our country. We speak about this period of time from 1948 like the period of totality, the totality in Czech Republic and the state of the absolute powers of Communist Party, restrictions on political freedoms, restrictions on ownership, and so on and so on. Concerning private law, there was announced by the communists so-called 2 years plan. 2 years plan in the branch of law, and the result in private law, you see two acts. You see Act on Family Law and you see a civil code. Yeah? You don't need to memorize the numbers. Yeah? It's just to make it more complete, yeah, for you, but you don't need to memorize these numbers. Important is that here we have, after 1948, we have new civil code and new act on family law. So you can see that's the Soviet shape of private law, where family law is separated into a separate act. Yeah? The family law is no more a part of a civil code, but family law is separated into the separate act. Yeah? That's the Soviet shape of private law. Yeah? The civil code and family law outside from the civil code. Yeah? Now we will move forward quite quickly and we will skip into the 60s. Because here we have to mention again concerning the development of private law, we have to mention again new civil code and new act on family law inside. Why in the 60s again new civil code and new act on family? Because in 1960 we have adopted new constitution. New constitution was adopted and we call this constitution socialistic. A socialistic constitution. Why socialistic? Because in this constitution it was declared that we have already reached the socialism. Yeah? We have already reached the socialism. And socialism is the last stage of social development before reaching communism, which was the main idea of the Communist Party, yeah, to reach the communism. So, as a political proclamation, yeah, it was said in this constitution that we have already reached the socialism, and being it so, having reached the socialism, we need new fundamental acts for all the branches of law, which means also the civil code, which means the family law. Yeah? What's the difference between socialism and communism? Yeah? You are a young generation, you probably don't know, so I can explain it for you in a quite easy way. Yeah? In socialism, everybody will be awarded in accordance with his work. Yeah? That was the idea for socialism. In socialism, everyone is awarded in accordance with his work. You obtain a kind of salary, yeah, for your work. However, in communism, you will be awarded in accordance with your needs. You will be awarded in accordance with your needs. And that shall be the final stage, the heaven on earth, which actually never appeared here and even never appeared anywhere else on our planet. You will be accorded in accordance with your needs, means you can take what you wish and use it, and you don't need to pay for it. Yeah, that's the idea of communism as a final stage of a development of the society. Yeah, that was the basic idea of Communist Party, to reach the communism here, which was in fact not possible. Yeah, so that's what is behind this constitution, this socialistic constitution. Then we have here the year 1968, what happened at the end of the year or at the beginning of the next year. Yeah? What happened here, we turned into federation. Yeah? The one state which was previously united was here divided into two states. Yeah? And from the 1st January of 1969, we had Czech Socialist Republic and Slovak Socialist Republic. Yeah? This is what happened here. Yeah? Then we have to mention the term Velvet Revolution and the year 1989. Velvet Revolution. Yeah? It seems maybe strange. The revolution and velvet. Velvet is a kind of material which is nice, decent, polite, let's say, and together Velvet Revolution, somehow it can seem as a strange connection of these two words. So why we call it Velvet Revolution? We call it Velvet Revolution because it was in fact a peaceful collapse of Communist Party, and it was a peaceful end of the communist regime in our state. Yeah? It was not as peaceful as it can seem, because on the 17th of November 1989, the students went to protest against the communists, and they were beaten by the police. But then all the remaining process, then all the remaining demonstrations against communists and the collapse of Communist Party, this was peaceful. Yeah? So there was some violence at the beginning, but in general, the whole process of the collapse of the Communist Party and its powers over the state, it was peaceful, let's say. Yeah? So this is why we call it Velvet Revolution. And after 1989, we again have returned to principles of democracy, rule of law, and also to respect to fundamental human rights and freedoms. Yeah? So this is in short, and one final point in our history. What happened at the end of 1992 and at the beginning of 1993. There were two states from 1969, but they were still covered with the federation. Yeah? From 1969, we had one president, still one president of the Czechoslovak Federative Republic. Yeah? But what happened? From 1st January 1993, no more the federation exists, and so only two independent, separate states are remaining here after 1st January 1993. Yeah? So before we were covered together with the federation, yeah? But from 1st January 1993, we are only two independent states, and there is no more federation, no more federal government, no more federal president covering the whole state. Yeah? So this is how it works from 1st January 1993. Concerning private law, there was no change because in Czech Republic the civil code from 1964 remained in force, also the Act on Family from 1963, and also in the Slovak Republic these codes still remained in force. Yeah, the legal system was the same, but today it's a long time, of course, from 1993, and today the legal systems are different. Yeah? So today we have new civil code, but the Slovak part, the Slovak Republic, is still preparing its civil code. Yeah? And it means this is the end of history, because we are at the civil code which is now at the moment in force, and you see it is a civil code under number 89/2012, collection of laws, and you see It was in force from 1st January 2014, so there were 2 years time to be prepared here. So in force from 1st January 2014, and you see quite a large number, a huge number of sections inside. Yeah? And perhaps now you are unhappy. How shall I be well oriented in 3,000 sections? Yeah? Don't be afraid. We are aware of this, and we don't examine you in a way like, tell us what is in a section 2075 of the Civil Code. Yeah? Again, that's not the way how it works here. I have now to introduce you this actual Civil Code. I have to make some kind of introductory notes to this Civil Code. The first note is what is it inspired by? Yeah? Because it was prepared in a way like, let's use what is here from the past. Yeah? It was not a preparation of a new civil code. We will open a window and we will write a totally new civil code. Definitely not. Our civil code is in fact a compilation of other provisions from other civil codes. And the first position here for inspiration, you see, is General Civil Code from 1811. That's the historical tradition from Austro-Hungarian Empire, plus the draft from 1937. Yeah? Now you see why it was important to mention that there was a draft which has never been adopted from 1937, because these two together, that's the inspiration number one for our civil code today. There are two opinions concerning this. Yeah? The first opinion says, yes, that's perfect. The General Civil Code is still in force in Austria. It was a really perfect private law code. So it's nice that you are still using it. Obviously, in Austria, it was many times amended. Yeah? And so that's fine. And there is a second opinion, dissenting, which says, oh, you should not to take as a fundament for your actual private law, the private law which is over 200 years old. Yeah? That's not the way how you should deal with it, because the General Civil Code is simply quite old, and the society was developing through the 2 centuries which have passed from the General Civil Code was adopted. Yeah? So there are 2 opinions. We can agree, we can disagree, but that's all what we can do, because it's simply the fact. Many provisions in our actual civil code are inspired by the General Civil Code of Austria from 1811, plus the draft from 1937. There are also other sources of inspiration. You see, let's say, West European civil codes, yeah? France, Germany, Switzerland, Italy, Spain, and also Quebec from Canada. We have some provisions also from Canada and Quebec. In fact, we have in our civil code a kind of trust. Yeah? The trust is an institute of common law system, of common law system, the trust, and it's also enacted somehow in Quebec. And in Quebec, you have both influences of common law and of the French law, of course, and the provisions about the, let's say, trust, simply speaking, we have adopted from Quebec. Yeah? So you can find also similarities with the Quebec from Canada. And maybe surprisingly, also the law from the communist era, from totality in our state, surprisingly, but this applies especially to family law. Yeah? We simply continued in the shape of family law, which was introduced by communists. The point was that in 1949, the communists, they have introduced the modern shape of family law. Yeah, the modern shape of family law. From 1949, we have equal position of husband and wife in our country. Yeah. Quite early, if you compare with other countries across Europe. Yeah? From 1949, we have the equal position of husband and wife. From 1949, we have no difference if the child was born to a married couple or unmarried couple. Yeah? Also from 1949, quite early, if you compare across Europe, we have this modern features in family law, and that's the reason why we simply could continue in using the family law introduced by the communists earlier. Yeah? So this is what is actual civil code inspired by, and what is it about? Yeah? In general, you should be able to explain to every people around you what is private law about. Yeah? And in the most easiest way, you are able to explain what is private law about by using only 3 words. And these 3 words are representing the fundamental institutes of private law. Private law is about family. Private law is about ownership, and private law is about contract. Of course, not only about these, yeah? There are many other instruments inside, but these are the fundamental institutes of private law. This is what private law is always about, yeah? These 3. And if you compare, and now here an advice for you, don't be afraid of civil code composed of 3,000 sections, because the civil code has some kind of structure. And the first in the structure, we have division on parts. Yeah? And our civil code has 5 parts. These are the fundamental parts, the fundamental components of our civil code. If you go general provisions on first place, that's clear what you will probably find there. Provisions on persons, provisions on acts in law, provisions on statutory limitation, and so on. These really general things which will apply everywhere. Yeah? Then you see number 2, family law. What is it about? It is about family, obviously. Yeah? Number 3, absolute property rights, including the law of succession, the inheritance law, let's say. And here, the key instrument is ownership. Yeah? Of course, you will find also another things here inside, but the key institute here in part 3 is ownership. Yeah? Number 4, relative property rights, which means obligations, which means relations between debtor and creditor. Yeah? And these relations between debtor and creditor are mostly arising from a contract, or sometimes also from the breach of law. They are also arising from the breach of law, which means from the delict. Yeah? A delict. So if you compare, and then the last part, the joint transition and concluding provision, that's the technical part of the code. Yeah? So if you compare family, ownership, contract, you see Part 2, Part 3, Part 4. Yeah? So the Civil Code, in its core here, is respecting the three fundamental institutes of private law. Yeah? There is, of course, something general before, and there is, of course, something at the end. Yeah? But the core here respects these three fundamental institutes of private law. Yeah? This is how we deal with this. And what is very important for you, because you are from different countries, I have uploaded the English version, yeah, that's prepared in the information system. But you see we have more translations available. We have a translation into English, but also into German, French, and Russian language available. Yeah. You don't need to copy this now, because I will upload you the PowerPoint and you will simply copy and paste into your web browser. Yeah? At the moment, keep in mind one thing. Yeah? The translation deals with the Civil Code in a shape as it was adopted in 2012. Yeah? The translation is the first version of a text as it was adopted in 2012. However, today we have 2021, and there were some amendments of Civil Code. Yeah? These amendments are not here in these translations. However, for the purpose of your study, it's enough to work with these translations connected with the first version of a text of a Civil Code as it was adopted. Yeah? And should there be some change, so we will inform you. Yeah? So just keep this in mind. Yeah? So this is how to use the Civil Code, how to work with the Civil Code, and especially always you can recall that we have 5 parts. Yeah? Because should you search for some provision concerning husband and wife, definitely you will search here. Yeah? Should you search some provision concerning the ownership, definitely you will search here, not here, not here. Yeah? So this is how to be well oriented in our Civil Code. Always you shall remember that we have this particular division for 5 parts. Yeah? But the private law is not in Czech Republic only the Civil Code itself. Yeah? We have to mention also another sources of law. So again, just shortly, first one is the Constitution of Czech Republic. That's the actual constitution. You see the number, yeah, 1/1993. There is, in fact, nothing interesting about the private law. That's, in fact, the division of powers in state. Yeah? This is what you can find in constitutions usually, and it applies also for the Czech Republic, the division of powers, the legislative, the executive, and the courts, yeah, the judiciary. However, the constitution is followed. You see the number 2/1993. The Constitution is followed by the paper of fundamental human rights and freedoms. And inside this paper, you can trace provisions which are the fundament for private law. For instance, you can you can find the provision expressly enacting the ownership is granted. Yeah? Everybody is entitled to be an owner. Yeah? The succession, the legal succession is granted. Yeah? This is what you can find in the paper of fundamental human rights and freedoms. Then the Civil Code. Here maybe we can mention the number. you see 89/2012. 89. The number 89 is a number which appeared in our history. Yeah? Is it a coincidence or not? Yeah, because if you go back, you see that 89, that's the year of Velvet Revolution. And I can reveal you the secret. Yes, this number is really to remind us that this civil code is the civil code for the new era, after communism, after Velvet Revolution. Yeah? Civil code, the number is not a coincidence. It was intentionally elected, here the number, and taken under this number into the collection of laws 89 to recall the year of Velvet Revolution and the end of the communist regime in our country. Yeah? We have also to mention a civil procedure code, but here be aware and don't be confused with the word civil here, the civil procedure code, because the civil procedure code is not a part of private law. Yeah? It is a part of public law. Yeah? You have the basic division of law, the private and public. I have a slide on it also for you prepared. But the Civil Procedure Code is a source of public law, not private. The reason is that the Civil Procedure Code is dealing with relationships where you have on one side you have a state represented by a court, and on the other side you have individuals, and these individuals, they have some kind of dispute, and the state will use its powers, the state will use its authority to decide on the dispute between individuals. Yeah? That's the triangle of a classical civil process. You have two individuals with a kind of disputes, and the court, which means the state, will decide, will use its powers, its authority to decide on it. Yeah? So that's the reason why the Civil Procedure Code is a source of public law, not private. However, the private law is not only the civil code. Yeah? The private law you can find also in other important acts. For instance, the Copyright Act, you will have a lecture on it later. The Labor Code, dealing with relationships between employers and employees. Yeah, that's the Labor Code. These are very important also sources of private law in Czech Republic. And just to show you, just to demonstrate, again, not necessary to memorize, yeah? Just to show you that you can trace the private law also in many other acts, many times quite surprisingly. Yeah? For instance, the first one, yeah? There are in Czech Republic kind of specifically protected animals. Yeah? The beaver, the otter, and these animals, and you are not allowed to kill them, yeah, in the fields, yeah, and if they will eat something, they will eat your harvest, for instance, so then you can ask for a compensation, yeah. However, asking for a compensation for a kind of damage, that's private law. Yeah? The second is the same situation. Yeah? Act on peaceful use of atomic energy and ionizing rays. Yeah? Should you suffer some damage from this, you can ask for a compensation. Yeah? And that's the private law question. Yeah? And the last one, really strange here, Act on funeral services. You can find here inside a specific kind of a lease contract. You can lease a tomb, you can lease a place where you will rest after you are dead. Of course, you will lease it when you are living, yeah? But that's a kind of specific lease contract. And a lease contract, that's private law, yeah? So you can trace elements of private law also in many other acts which are a part of our legal system. Yeah? So it's just to give you the idea more complex. I have here the slide which was promised on private and public law, what you should know about the division on private and public. You should know that this division is quite old. It comes from ancient Rome. Yeah, you see here the Latin phrase from Ulpian, which was the ancient Rome lawyer who was characterizing the difference between private and public law. Yeah? The public law is that one which is connected with the state, let's say, with the Roman state, and the private law is that one which the individuals are using when interacting each others. Yeah, so that's the definition. Just shortly explained. Definitely, we will not ask you to memorize it, but you should know that the origin of private and public law is really old and comes from ancient Rome. Private law is based on some particular principles. Private law is based on some particular principles. It's the last important topic for today, I think, because we are limited with the stream as well, so I have to look for the time always. So here I have 8 principles, yeah, listed. 1, 3, 4, and 7, the numbers are in bold, which is to indicate we will discuss these in a bit more detailed way later. Yeah? So first of all, concerning the principles, you can find the section 3 in Civil Code, where some of these are listed, but some other principles are not listed in a section 3. Yeah, the section 3 is a list which is, however, opened. Yeah, in section 3 you have some principles expressly enacted, but we stay on an opinion that also other principles are forming the private law. Yeah, and no matter that they are not expressly listed here in section 3 of Civil Code. So the first one we will discuss later. Anything not expressly forbidden is permitted. I think it does not need further comments. It's clear. Equality we will discuss later. Protection of weaker party we will discuss later. And here again we have Latin, pacta sunt servanda. Who is able to translate? Just raise your hand. Who is probably able to translate? Yeah. Pacta sunt servanda. What does it mean in Latin? Do we have some offers? One offer. The contracts have to be kept. Yeah. You are binding by the contract you enter into. Yeah, the contract is binding. Yeah, you have to keep the contract. Yeah, exactly. And we add also a promise is binding. Yeah, the point is a contract needs 2 or more parties to be binding. Yeah, you need an offer and you need an acceptance. And also a promise. A promise is unilateral. You need just one subject to offer a kind of promise. Yeah? it is also binding. Yeah? Once you will promise, it will be binding, and once you enter into the contract, you have to perform. You have to deliver your performance because it's binding. Yeah? So contracts shall be kept. Yeah? So that's pacta sunt servanda. The point is that in Czech Republic we still tend to use the Latin phrases in private law and during the education because the teaching of Roman law has really strong and long tradition. Yeah, in Czechoslovakia. So we still are able normally to understand, yes, pacta sunt servanda, the contracts are binding. Neminem ledere means that you have to behave in a way that you will not cause damage. Yeah? You shall to behave in a way not to cause damage to other people's life, to other people's health, to other people's property. Yeah, neminem ledere. That's a kind of prevention. Yeah, behave in a way that you will not cause any harm to other people's life, health, or property. This is the one we will discuss later. And the last one, again in Latin, nemo plus juris ad alium transfere potest, quam ipse habet. Simply, no one is allowed to transfer more rights than he possesses. Yeah? No one is allowed to transfer more rights than he possesses. Just an example. If I'm an owner of this really ancient cell phone, as an owner, I am able to sell it, I'm able to donate it. Yeah? But if now I'm using this marker, this laser marker, we are really modern here, so it's not mine, obviously. Yeah? I'm only allowed to use it, but it means I'm not allowed to sell it, to donate it, because I'm not an owner. Yeah? So that's number 8, nemo plus juris ad alium transfere potest. Nobody is allowed to transfer more rights than he possesses. Yeah? And now more closely to the autonomy of will. You see the section 1, paragraph 2 of the Civil Code, and you see here the meaning of this autonomy, or let's say freedom. Let's say freedom. You are free to behave in your own way. Yeah? You are free to decide if you will enter into the contract with Mr. Green or if you will enter into the contract with Mr. Red. Yeah? You are free to decide. Yeah, that's your freedom. That's your autonomy. A space, an area where you can decide what you personally prefer. Yeah. However, there are some limits. There are some limits, and you can see the limits inside this provision. The first one, express prohibition by a statute. Yeah, that's the first line. If the statute expressly prohibits something, then that's the limit of your freedom, that's the limit of your autonomy. And then there are also other limits of your autonomy, because you are not allowed to behave in a way contrary or breaching good morals, public order, or you are also not allowed to breach the law concerning the status of persons, including the right to protection of personality rights. Yeah? So, let's give some examples concerning the last two. The protection of personality rights. Yeah? you are not allowed to hurt some other person, yeah, to invade into her privacy, yeah, for instance. That's what you are not allowed, yeah, especially to hurt another person, even if the person wish you to do so. Yes, be so kind and please cut off my head. You are not allowed to do this, yeah, of course, yeah. That's the protection of personality rights. The law concerning the status of persons. For instance, once you get married, you are entitled to get a divorce. That's your right. And once you get married, there is the change of your personal status. You was free, and now you are married. And because you are married, you are always entitled to get a divorce, yeah, in accordance with the legal system, of course, yeah. And let's imagine that you have a couple, husband and wife, and they want to enter into the contract, and in this contract they want to waive their right for a divorce. They will say, we will be together till the death will separate us, so no right to get a divorce. I agree and I will put it into the contract with my wife. And she agrees and she also wants to sign such kind of contract. It's not possible. This contract will not be legally binding because you will breach the law concerning the status of person. Yeah? Or another example, you have probably heard about surrogate mothers. Yeah? You have a couple, man, woman, but the woman is not able to carry the baby or deliver the baby. So they ask another woman to be pregnant for them to deliver the baby, and then they will again take the baby. This is what we call surrogate mothers. And in Czech Republic, I will mention it later when speaking about family law during over next lecture, but it's nice example also here in Czech Republic. We always have a rule in every single case. The mother is a woman who gave birth to the child. Yeah? The mother is a woman who delivered the baby. And should you try to enter into the contract like a transfer of a maternity? I will transfer my maternity to you by a contract. That's not possible because you are breaching the law concerning the status of a person. Yeah? So this is also the limit of the autonomy of will. Equal position of subjects. In private law, we are equal. We are formally equal. Yeah? However, this principle is not expressly enacted in civil code, but it doesn't matter. We still have this principle. And we have here a really short case study. Let's imagine you offer a kind of letter and there is an offer inside. Yeah? I offer you a kind of goods, books, I don't know what, and should you not respond within 14 days that you refuse this offer, I will consider it as your consent. I will send you the goods and I will, namely, claim the money for it. Yeah? And at the moment, here, you see the principle of equality. You can simply go and put this offer directly into the dustbin. Yeah? And no contract will be concluded in this way, because if we are equal in private law, it means nobody can impose a duty on me to respond if I don't wish so. Yeah? We are equal, So the second party, or nobody, is able to impose a duty to do something on me. Yeah? I have first to agree. Yes, let's go to impose a duty on me. But there was no such kind of agreement. Yeah? And here somebody tries, by his unilateral will, to impose a duty on me, to respond. Yeah? This is how it will not work in a private law. Yeah? So inside private law, the contract will not be entered into because the subjects are equal. They are formally equal. However, are legally equal, and formally equal, but they are not equal in a real life. And we know that we are not equal in a real life. And that's the reason why we try to protect the weaker, or let's say disadvantaged, or let's say vulnerable person. Yeah? Some examples. Who can be a disadvantaged party? Who can be a vulnerable person? Yeah? Give me examples. Who can be, yes? Exactly, children, precisely, children. Who next can be a weaker party or a disadvantaged party? A consumer, yeah? Yeah, and there is a yes, elderly persons, that's the actual debate also in Czech Republic, if we shall more protect the elderly persons, yeah. But this debate is still not at the end in Czech Republic. So you see a child, you see a consumer versus an undertaker, you see a person with mental disorder, and also we take as a weaker party a lessee in a case of lease of a flat. Because living in a flat, that's your basic need, fundamental need. And if you are not the happy one to be an owner of a house or of a flat, then the only possibility how to live in a flat is to lease a flat. Yeah? So that's the reason why we take also a lessee in a case of a lease of a flat as a weaker, or let's say disadvantaged party. Fine. The last one to be discussed more in details, the protection of a good faith. Yeah, the protection of a good faith. Be aware of it, because in Czech Republic we use the notion good faith in the subjective sense. Yeah? It means a state of my mind. I'm thinking something. The state of my mind is somehow determined. For instance, you are in a shop with computers, you are buying a notebook, a laptop, and everything seems to be perfect. A documentation is there, you pay for it, you obtain a bill for it, everything seems perfect, so you are in a good faith that everything is all right, there is no problem. However, in fact, the laptop was stolen before, yeah? And that's the problem for your ownership. But because it happened in these circumstances, in a shop and so on, and everything seems okay, there is even an original box presented for the laptop, so you have no idea that there should be some kind of problem, yeah? That the laptop was stolen. Yeah? So there is some kind of your protection, yeah? Because you was behaving correctly, yeah? And the other party made something bad. Yeah? Let's compare with a situation where somebody stops you suddenly on a street and offers you a car. Yeah, come on, I have a car for you to sell. That's really a deal. I will give you a discount. It doesn't matter I have not the keys present. It doesn't matter that I have no documentation. It doesn't matter the window is broken. Yeah. just buy it and the engine is working, so jump into inside and go. Yeah? So here, as a reasonable person, you have to see that here probably there is really a problem, that somebody who is offering this car is probably not an owner. Yeah? So here you will not be protected, because there were these circumstances connected with the situation where the reasonable person sees that there is some problem, obviously. Yeah? So that's the subjective sense of good faith. Yeah? In other legal systems, time to time you can see a definition of good faith in an objective sense as a set of general rules or good morals, honesty, decency, politeness, and so on. Yeah? So be aware of this difference, good faith in a subjective sense, a state of mind, or in objective sense, a set of general rules, some rules, yes, somehow defined, but in Czech Republic, we tend to use this in this subjective sense. Yeah? That's important to mention and to distinguish. Dear colleagues, being limited with a stream on time, being exhausted, yeah, being in a pandemic's surrounding without fresh air, I think it's time now to finish. I will thank you for your attendance for today. I will wish you a good study here and a good stay in Prague, and I do hope we will meet again during next private law lecture. However, please try to split yourself between the two lectures. One is from 12 and one is from 4 p.m. Yeah, so try this amount of persons, try to split. Yeah, okay. Thank you very much and goodbye. Have a nice day. So, good afternoon. It seems we are now online in time. This lecture is also streamed, so that's the reason why I'm forced to use the microphone, despite the fact that the audience here wouldn't probably require. Yeah, so that's first thing. Second thing, I'm Ondřej Frinta from Department of Civil Law. I'm not going to tease you with the Czech R, Ondřej. It's simply in English Andrew. Yeah, it's just to let you know. And we will start today the course on private law here in this time, and first of all I have to say something concerning the organization of a course. But first of all, what I will show you, how to deal with the web page of our Faculty of Law and how to jump into students' information system. It is important because inside the students' information system there is a board where we are uploading materials for you, yeah? And some materials are already prepared inside. So what you see here, that's the web of the Faculty of Law of Charles University. You see it's in Czech, but you see in the corner, obviously you can switch into English. And you see here the line, and here you can see the abbreviation SIS, which means the Students' Information System. Yeah? So in fact you can switch into English, yeah? Because here you can see again the Students' Information System, also in this English version. So it doesn't matter if you go from this version or the Czech version into SIS. And now you see here the first page of the Students' Information System, which is at the moment in English. And you see here these subjects. Yeah, subjects. However, to see the files, you need to have your login and you need to have your password. Yeah. I will log into the system, which now is in Czech. However, again in the right upper corner you see the British flag and you can switch into British. And again here you see the subjects, and if you go subjects, you see something what does make sense to you. Maybe from your point of view it looks like a bit in a different way, because I have my teacher's view and you have your student's view into the system. However, what is the same and is important, my courses, and here you have a list of courses. In my case, it's a list of courses when I'm teaching. In your case, it will be a list of courses which you decide to study, to enroll in, and you have to be recorded, to be added into the course in the system. They will tell you how to do it if it already doesn't happen. And you can see here in the list there will be private law. Yeah, that's this private law. And if you click on private law, you see some kind here of description of the subject. Here you can see also a kind of description and some kind of statistics. But what you are interested, here you can see files. Yeah. Here you have files, and something is already prepared here for your download. In case of your interest, the Civil Code translated in English. Yeah, that's the first file here. The second file is my text, my text about the new civil code which is in force. This text was prepared for our Korean colleagues. That's here the name Law Crossing Eurasia. So to make our Korean colleagues familiar with our new civil code, and I think it's in English, yeah, and it's a good text for you to read if you want to have more additional information concerning the development of private law in Czech Republic and concerning actual civil code. Here this file with the name Hrstkova, it means Jana, Jane, Jana Hrstkova. It is our special expert for contracts. And you will have a lecture with her, and there is a textbook from her about private law in general. However, unfortunately, this textbook is a bit older because it's connected with the old civil code, which is not already in force. So if you study from this, you have always to compare with the actual wording of a civil code. And you can study, let's say, more general questions about persons, about principles of private law. This can be studied from here. Yeah? Here, this one, Macková civil procedure, it's clear what is it about, the civil procedure. You have one lecture, it's a kind of introduction into the Czech civil procedure, so you can use this material as a support if you wish to obtain more information. And the last one, there is the list of lectures, again, to be prepared here for you and to be downloaded if you wish. The list of lectures, what we will have in this winter term. Yeah? So this is already prepared, and this is the place where we will upload the PowerPoint presentations from lectures. Yeah? I will upload here my PowerPoints from these lectures, which I will have, and also my colleagues, they will upload here their PowerPoint presentation, yeah, from their lectures. Yeah? So that's the reason why it was important to show it where you can find all these files. So you need to use the students' information system, and you need to be logged in. Yeah? And here I will log off, and that's all. And you see again it's in Czech language, yeah? And I'm away from it. It is also connected with the question, what's the aim, the main goal of this course, and how it is organized. We are not going to tease you with particular details about Czech legal system and about Czech private law. Yeah? We have a civil code with over 3,000 provisions. And definitely we are not teaching here in a way like, so what is in section 923 enacted? Yeah, it makes sense, obviously. Yeah. So we want to give you, let's say, complex overview on private law in Czech Republic. We want to give you a kind of more general knowledge about private law and its particular branches, which maybe you can use for comparing and contrasting when you return home, when you continue in studying at your university, so you can recall and compare and contrast the general things. Yeah? 11 lectures prepared, and it's not one-man show. You will meet me, I think 4 times, next time, over next time, and I think over next time. So I think I will appear here 4 times. but I think it's enough to see me for 4 times. Yeah, it can be then boring. Yeah, to see me again and again. So we have this course prepared not as a one-man show, but then you will experience really the experts in trying. Yes, now. Problem is I have to use it because of the stream. Yeah, yeah. Now it's fine. Maybe I will then switch to this ones. Yeah. So particular branches, particular experts. Yeah. Dr. Hrstkova, an expert on contracts. Associate Professor Elisher, an expert on ownership. And so on, and so on. Associate Professor Štefko, an expert for labor law, yeah, and so on, and so on. So it's not one-man show, and please take it as an advantage that you can experience more teachers, more experts, you can experience a different attitude of each of us to you, yeah. However, and what you are definitely interested in the end is the exam. So here you can see the date of the exam and times. It is also written in the list of lectures which is prepared in ASIS, yeah, this information. 17th December we prefer to examine you before Christmas so that you can leave and to have your Christmas in your home countries. There are two groups of private law. The first group is the group A, which has the lectures from 12 usually from the noon, and the second group has the lectures usually from 4 p.m. Yeah, today it's the exception for this second group, and I will be glad if you will really use this second group from usually 4 p.m. Because here it's not so overcrowded, yeah, and probably we will try to push some of your colleagues also into this group because here still a lot of place available, yeah, so that you can spread. You are not obliged to sit just in the back of the class, yeah. I'm not any bad person to do you something bad, so next time you can spread around the class, there's no problem with it, yeah, and you can probably more enjoy the PowerPoint, yeah. Concerning the exam, we are quite polite to you because the exam is a multiple choice, A, B, C, D. You have 4 possibilities. But only one, and always one is correct, yeah, which makes it more nice to you. It's not so complicated because usually you are able to find the one which is correct. Yeah, it can be also hard sometimes and complicated, but definitely this is more kind shape of the exam than the second possible to have the possibility 0, 1, 2, 3 or 4 correct. Yeah, then it's more complicated for you. Yeah, so we try to give you this which is I think more comfortable also for you. At the moment, the pandemics and the situation in Czech Republic looks like that you can be present in classrooms, you can take your exams in classrooms. So at the moment, we are planning the classroom here, the exam in a classroom, sitting here, when you are sitting here, so it's the closed book exam, you have just to file the multiple choice and that's all, yeah. However, it can happen that the pandemics will develop in a different way, and in this case, we will of course inform you in advance that you will have examination online, which means again we will just send you some kind of multiple choice, and we will you to send it to us back in some particular time, and that's all. Yeah, so don't be afraid about the exam and how to study. If you are present during lectures here, if you will download the PowerPoints which will be uploaded, and you will just go for a repetition through the PowerPoints, it's the basic fundamental way how to be well prepared, plus you have these additional materials if you want more information. Yeah? So your study material number 1, PowerPoints and lectures. During the exam, what we are asking? We ask on questions which were mentioned expressly during lectures. What was mentioned here, it can be examined. Yeah? We will not examine you in a way. Tell us what's on the page 70 of the textbook of Dr. Hrstkova. Yeah, that's not the work not the way how it works. Yeah, so what was mentioned here, this can be also added into the exam. Yeah? So this is about the organization, and you are the second group, so your time is 10 minutes after 5 p.m. Yeah, 10 minutes after 5, that's the time for your group. Yeah, so take this in mind. Okay, it jumped so far now at the end. Oh, I see. So now we are back. Concerning the organization, everything is clear. What you can expect, yeah? What we can expect. Usually students are doing quite well during the exams. Just keep in mind one limit or restriction. Once you are awarded with B grade, C grade, D grade, there is no retake possible. Yeah? Retake is possible only if you fail. Yeah? Only in this situation you can have a retake. We have even 2 retakes possible if you fail. So you can fail for the first time, for the second time you can fail, but for the third time you have finally to succeed. Yeah? I don't remember happening this. Yeah? Very often, let's say. Okay, so this is about the exam, and now I have to lead you in. I have to introduce you the private law in Czech Republic. And to give you a proper introduction, I need to speak a bit about history, and about the historical development, so that you are then fully able to work with the situation which is today. Yeah? So you have also to know something about the history and about the development. I will just go only through particular points. Yeah? Don't be afraid of it. Yeah? But today it will be more me who will speak to you, but next time I will prepare a sheet of paper for you to work and to have a teamwork or something like this. Yeah? But today it's more frontal from me because it's the introduction. Yeah? Unhappy introductions always. However, what you see is a picture with a lot of colors, which is, I think, not so boring. And you see it is a map from 1919, quite an old map. And what you see are here the new states created when Austro-Hungarian Empire collapsed. You see the newly shaped Italy, Austria, Hungary, Romania, Poland here, Yugoslavia also, and what we are interested in is the Czechoslovakia, or precisely said, the Czechoslovak Republic. Yeah? This state was created after the collapse of the empire, and you see it was created as a one united state, however composed of two main nations, the Czechs and the Slovaks. Yeah? These two main nations were here together put into this one state. When did it happen? It happened on the 28th of October 1918. You see, it's in October, there will be, in a few weeks, there will be state holidays, and these holidays, it's to remind us for the anniversary of the Czechoslovakia, the 28th of October of 1918. From the point of view of private law, what does this mean? In Austro-Hungarian Empire, you probably know that the private law was enacted in 1811 into the General Civil Code, Allgemeines Bürgerliches Gesetzbuch, General Civil Code from 1811. However, the collapse of the empire was so fast that there was no time to prepare new legal system for newly created Czechoslovakia. Yeah? So what we did, we simply said, we will in the first moments of existence of Czechoslovakia, we will continue using the Austro-Hungarian legal system. Yeah, continue in using the Austro-Hungarian legal system, also in newly created Czechoslovakia. And we have said this by so-called Reception Act. It's a bit strange because in English the reception means, in the first place, it means the front desk in a hotel. Yeah, that's the reception in English. Yeah, but it can have also another meaning, not so usual, and it means to continue in using, to take something old and to continue in using this. Yeah, and we continued in using the legal system of Austro-Hungarian Empire. However, this had quite an interesting consequence. There happened something what you will probably not experience very often. It's quite exceptional, really rare, because the point is that the General Civil Code from 1811 was used and was in force only in the Austrian part of the monarchy, here, let's say. Yeah. However, in the Hungarian part of the monarchy, this General Civil Code was not in force, and here private law was composed mostly of legal customs. Yeah? So here the General Civil Code is in force, and here legal customs in private law. So if you say, okay, we will continue in using the legal system in general, it means that in the Czech part of the Republic, we were using the General Civil Code. However, in the Slovak part of the Republic, we were using legal customs in private law, which is quite strange, because you have one state, one united state. However, you have two different private law systems inside. Yeah? And obviously, this is something you don't want to have, because it's hard to be well oriented. Yeah? It's hard to enter into the contract. I am under the General Civil Code, and the second party is from Slovakia, from the Slovak part, is under legal customs in private law. Yeah? So it was clear that we need to do something with this, and a draft was finished. This draft should be in force both in Czech and in the Slovak part of the Republic. However, it never happened. This draft was never adopted because of the Second World War. Yeah? So there was a draft prepared, but has never been adopted because of the Second World War. What happened after war, after the Second World War, 1948, that's the year when the Communist Party started here in Czechoslovakia its absolute powers. Every powers were concentrated into the hands of the Communist Party. Yeah? So there were many restrictions on political freedoms, many restrictions on ownership, and so on. But from the point of private law, you see here two results of this 2 years plan, which was announced by the Communist Party. After 1948, they have announced this 2 years plan, and the result is this. You see two important acts, a civil code and Act on Family Law. And this is the Soviet shape of private law, of the regulation of what we call private law, because you have civil code without family law inside, and family law is here in a separate code. Yeah, that's the Soviet shape of regulating these things. So that's the start of the totality in our state. We call this period of time of the communist regime, we call it as a totalitarian state, as a totality in our state, which is the opposite of a freedom. Totality is, simply speaking, the opposite of a freedom. So that's the year when the totality started in Czechoslovakia. We will move forward quite a lot, we will skip a lot, and we will speak shortly about the 60s. At the beginning of the 60s, in 1960, we have adopted new constitution. New constitution, which was called socialistic, the socialistic constitution. Why socialistic constitution? Because in this constitution, it was declared that in Czechoslovakia, we have reached socialism. We have reached socialism as a stage of development of our society. Yeah? Having in mind, and you are quite young, probably you don't know or you don't remember the ideas of Marx and Engels, there is a socialism as a last stage before the final one, and the final stage, which they think should be, was communism. Yeah? That's the reason why all these parties, they have the communism in their names, in their titles. Yeah? The last final stage of development of society should be communism, and one level before is socialism. Yeah? So this constitution was here adopted to motivate people, to tell them, look, we are just one step before communism. Yeah? And what's the difference? What's the difference between socialism and communism? It can be said very simply. In socialism, you are awarded in accordance with your work. In socialism, you are awarded in accordance with your work. In communism, you are awarded in accordance with your needs. You are awarded in accordance with your needs. That's communism. And that should be the last stage, because there will be a lot of goods available that you can simply take what you need and use it, and you don't even to pay for it. Yeah, that was the planned heaven on earth, but it has never happened, and nowhere. Yeah, so the socialistic constitution, which means from the point of view of private law, again, okay, we have reached new stage in a social development, so we need also new civil code, and we need new family code. Yeah? So civil code and Act on Family, or Act on Family Law if you wish, again adopted, again separate acts, yeah? And these were influenced by the ideology of reaching the socialism. What happened next in the 60s, you can see the year 1968. It's just again to give you a complex overview. The one state, however, composed of two fundamental nations, turned into federation. So what happened was that the one state was divided into two republics, the Czech Socialist Republic and Slovak Socialist Republic. However, there was these two states that were covered with a federation. Yeah? We were a federative republic from 1st January 1969. From the point of view of private law, it doesn't matter, these two codes, Act on Family and the Civil Code, they were in force in both parts of the federation. Yeah, the private law was the same in both parts of the federation. Then we have to skip much more forward to year 1989, into the year of Velvet Revolution. The year of Velvet Revolution. Maybe it can sound a bit strange, revolution and velvet together. Yeah? What can have the revolution have in common with the velvet? Yeah? What we want to express by this notion, Velvet Revolution, is that it was a peaceful revolution, a peaceful collapse of Communist Party, a peaceful end of totality in our state. Yeah? In fact, it was not as peaceful because the collapse of a Communist Party started on the 17th of November 1989. That's the anniversary of students. Yeah? And the students started protesting against the communists, and the students were beaten by the police. Yeah? So that was quite violent. However, then, the following process, there were many demonstrations then against communists, and the whole following process then, after this demonstration, was peaceful. Yeah? So in general, we speak about Velvet Revolution like a peaceful end of totality in Czechoslovakia. And when the communist regime collapsed, we again have returned to principles of democracy, rule of law, including the respect to fundamental human rights and freedoms. Last stage before we will reach today's is just to add what has happened at the end of 1992, or if you wish, at the beginning of 1993. We have said we have here two states from 1969 covered with federation, so we had one president. Yeah? And what happened from 1st January 1993, the federation terminated its existence, which means only these states remained here as independent states with its own president, with its own capital city, its own president, its own capital city. Yeah? But the private law was still the same. Yeah? We still continued in both states, these independent states, also after 1993, in using these codes, Civil Code and Act on Family, which is the moment where we can skip into presents, and we will now make some notes concerning the actual Civil Code. It was clear again that we need a new civil code because the code from 1964 was a socialistic civil code. And we are no more a socialistic country, so it was clear that we need a new civil code. And we have such a new civil code. You see the number 89/2012, collection of law. You see the date from which it is in force. You see there was 2 years of vacation. It was adopted 2012, but is in force from 1st January 2014. And you see that's the number of sections, over 3,000, which is quite a lot. So I hope I will help you how to be well oriented in this civil code, how to work with this civil code. But first of all, let's mention about the inspiration, because this civil code, that's the Czech version, is not something completely new. In fact, it is a compilation of solutions which were here before. And the inspiration number one, and it's really the position here, number one, the first position here, and now you see why it was important to mention the draft from 1937, because the inspiration number one is the General Civil Code, and the draft from 1937. Yeah? That's the inspiration number one. There are two opinions concerning this. Yeah? The first opinion says, yes, that's perfect. The General Civil Code from 1811, that was amazing code, really brilliant. It's still in force in Austria. Of course, it was many times amended, yeah, but it's still in force. That's perfect, yeah. And there is another opinion, dissenting, which says, yes, it was a perfect code, but it is over 200 years old. And the society and the people, all this has changed, has developed. So it's not a good idea to be inspired mostly in a over 200 years old civil code. Yeah? We can agree, we can disagree, but that's the only thing we can do, because it simply is the fact that the most of provisions of the actual civil code is inspired here. However, we have also other sources of inspiration. Let's say the West European civil codes, like the French one, German, from Switzerland, from Italy, even from Spain. You can trace some provisions also in our civil code, and even from Quebec in Canada. Also here some kind of inspiration. In fact, in our civil code, we have a trust inside. A trust is a typical for, simply speaking, for the common law system. And because in Canada and Quebec, you have both influences. You have the influence of common law and you have the French influence there. So they have, simply speaking, somehow the trust also in their civil law. And from Quebec, we have adopted somehow these provisions on trust, simply speaking. Yeah? And maybe it could be surprising why also the law from the period of totality is also inspiring our actual civil code, but this applies especially to family law. Yeah? We still are using the family law, which was introduced in 1949. Yeah? No matter about the ideology of communism and their totality, they have adopted quite a modern family law in 1949. Yeah? From 1949, we have equal position of husband and wife in marriage. From 1949, we have equal position of children. It is no question if they were born to married or unmarried couple. Yeah? That's no question, that has no legal significance. From 1949, which is, if you compare with other European countries, which is quite early. So once having this modern shaped family law, we just continue in using this family law also in our actual civil code. And you will see that the family law will be back in this new civil code. If you are called, feel free to close the windows. I was just changing the air from the first group, and to give you fresh air and to liquidate the virus. Okay. So that's the inspiration. And now, speaking about private law, you shall be able to say in 3 simple words, what is private law about? Yeah? What is private law about? You can explain it in a very complicated way, but you can explain it in a very simple way. Yeah? What is private law about? Always, it has to be about family, about ownership, and about contracts. You can here see 3 fundamental institutions of private law. This is what shall be always regulated in private law. This is what you need to make, let's say, a normal living possible, from the private law view. Family, ownership, contract. These are the basic instruments, let's say. And let's compare with the structure of civil code. The structure of civil code is here as follows. You can see 5 parts, and that's the first help to you. Remember that we have the civil code divided into 5 parts. Because once you will search for a provision about husband and wife, you will not go through all the 3,000 sections, but you will search here. Yeah? Once you will search for a provision concerning the property, the ownership, or also the inheritance law, the law of succession, you will search in the third part. Yeah? And once you will search a provision concerning the creditors and the debtors, the relationship between creditor and the debtor, this relationship mostly arises from a contract, but this relationship between creditor and debtor also can arise from a breach of law. So you will search here in a fourth part. Yeah? And if you compare family ownership contract, what you can see in the core of a family, of a civil code. This is the core. You see family law, you see absolute property rights, where the number one is ownership, and relative property rights, where the number one is a contract, which is establishing the relationship between creditor and debtor. Yeah? At the end, joint transitional and concluding provisions. This is, let's say, the technical part of the code. You will probably, during your stay, not study in this part. And general provisions, the most general instruments which will be then applied in all these parts. So let's say about persons, that we have natural and artificial persons, it's here. Yeah, provisions on acts in law, it's here. Yeah, provisions on statutory limitation and so on, it's here in the first part. That's the general part. Yeah, so that's the general part, that's the concluding part, and the core of the code respects the three basic institutes of private law. What is important to mention, the Czech Civil Code was translated also in foreign languages. You see English, Deutsch, and French, German and French, and a Russian version here. Just when you will download the PowerPoint, you can simply copy and paste this link into your web browser. I'll try the second one. Yes, and you will obtain the PDF file with your preferred language. Yeah. However, what you shall keep in mind, these translations were made after the Civil Code was adopted. So it's the first version of a text, yeah, without amendments. Without amendments. That's the first original version of the Czech Civil Code. There were later some amendments which are not translated here, but for your purpose, I think these amendments are more, let's say, minor, or particular details were amended. Yeah, so you you can be quite happy with these first versions of a text. Yeah. Sorry, third lecture for today, quite demanding. But let's continue. Private law in Czech Republic, it's not only the Civil Code. It's not only the Civil Code. We have to mention also other sources related with private law. The first one, the Constitution, you see the number 1/1993, that's the first law which was adopted after the end of the Federation, or it shall seem at least as it was the first law. the Constitution is not so interesting for private law, because what you can find in a Constitution, you can find the division of powers. Yeah? That's what are the constitutions usually about, the division of powers in a state. You have some legislation, you have some executive powers, and you have the judiciary powers and their division and the relationships. That's in the Constitution. However, the Constitution is followed by paper of fundamental human rights and freedoms. You see the number just following the Constitution, and inside you can find some fundaments for private law. For instance, there is a provision saying ownership is granted to everyone. Yeah? Everyone is entitled to be an owner. The legal succession after a deceased person is granted to everyone. Yeah? The family is under protection. Yeah? So here you can trace, let's say, kind of a fundamentals of private law, which are then developed here in a civil code. Yeah? On the other hand, it is also related, we shall mention it, but it's not a source of private law. Don't be confused with the word civil here, Civil Procedure Code. The Civil Procedure Code is a source of public law. It is a source of public law, not private law. Because if there is a dispute between two individual persons, and if they ask a court to decide, so you have a triangle, one individual, second individual, there is a dispute, and here is a court who will use its power, who will use its authority, who will act from the public position to decide over the dispute. Yeah? So this is the reason why Civil Procedure Code, be aware of it. It is not a source of private law, but it is a source of public law. Yeah? There are also other important acts which are linked with private law. These are important, and you will have particular lectures later on copyright, labor code. It's clear what is it about the relationships between employees and employers. But just to show you and make it again more complex for you, you can trace private law also in quite acts where you would not expect it. Yeah? The first one, we have in Czech Republic, we have some particularly protected animals, like is the beaver, the otter, and so on, and you are not allowed to kill them, even if they are going to eat your harvest. Yeah? But you can ask the state for compensation, and the state is liable for it and will compensate. But the compensation for a damage you have suffered, that's the private law question. Yeah? The second one, peaceful use of atomic energy and ionizing rays. Again, if you suffer damage in this way from atomic energy, again the state is liable and has to compensate. And again, that's the private law question, in fact. Yeah? And the last one, really strange here, Act on Funeral Services. Kind of morbid here. Inside, you can find a specific kind of a lease contract. You can lease a tomb, or you can lease a place where you will rest after your death. So it is a lease contract, quite a specific one. Of course, you are entering into it when you are living, or somebody else, a third person, is entering into this contract when you are deaf. However, the lease contract, that's private law. That's private law. Yeah? However, it's not in a civil code, it's in this strange act on funeral services. Yeah? So it is to show you that the private law is not limited only to civil code, to show you that we have also other important sources, and to make it complete also sources of no such importance as these two are, yeah, for you and from your point of view. Okay, I have mentioned the question of private and public law. Yeah? The division into the two main branches, private and public, that's a really ancient question. It comes from ancient Rome. You see here the phrase, the original phrase in Latin from Ulpian, who was a lawyer in ancient Rome, who for the first time has formulated the difference between private and public. The private is that what the individuals are using when they are interacting legally each other, entering into contracts and so on. And the public law is that one which is related to the state, yeah, to the republic. Yeah? So that's the way of division. Definitely you will not be examined in a way like give me an exact translation of this. Yeah? Just raise your hands. Who would be able to translate it? Who knows the Latin? Raise your hands. Not many, even not any. Yes. Unfortunately for you, in Czech Republic, we still tend to use Latin in law and in teaching the law, because here in Czech Republic, the education in Roman law has really a long and a strong tradition. Yeah? So for me, it's not a surprise to see this. Yeah? For you, maybe it is a surprise and you could have a problem with it. Yeah? So I was explaining it for you here and making you sure that you will not be examined from memorizing this, yeah, of course. However, having mentioned the basic division of law, private and public, we have to add, and this will be the last thing for today, I think, we have to mention that the private law is based on some particular principles. We have some basic, some fundamental principles, and again you see Latin here, because, and that's a bit of my fault, for me it's normal to say pacta sunt servanda, and I know what's going on, yeah, because of the Roman law tradition here, but for you, of course, I will explain. Yeah? The first one, here the number is in bold, the number 3, 4 and 7, these are also in bold. These I will discuss a bit later and in more details. Yeah? Now I will go through number 2. Anything not expressly forbidden is permitted. I think it does not need further comments more. It's clear. We will mention this later. This one we will mention later. And now we have again Latin, pacta sunt servanda. Yeah? Pacta sunt servanda. It means, I will not ask you because nobody raised the hand concerning the Latin phrases, so I'm not going to ask. It means simply the contract is binding. The contract shall be accomplished with. Yeah? The contract is binding, the contract shall be accomplished. you are free to decide if I will enter into the contract or not. I'm free to decide. But once I was entering the contract, once I have entered the contract, it's binding and I have to perform. Yeah? What was agreed. I have to deliver my performance. I have to fulfill the duties which I have taken to me by this contract. This is pacta sunt servanda. Yeah? The contract is binding. The contract shall be accomplished with. Also, a promise is binding. Also, a promise is binding. The difference here is for a contract. For a contract, you need at least two parties. For a promise, you need only one person. Yeah? However, both is binding. You have then to fulfill your duties. Another Latin phrase, simple one, neminem ledere. It is about the behavior in advance to prevent something. Yeah? Neminem ledere means do not cause any damage to other people. Do not cause any damage to other people. Behave in a way in advance so that other person will not suffer damage on life, on health, on property. Yeah? Behave in advance in a way that you will not cause harm or damage to other persons. That you will not damage the other person's life, health, or property. Yeah? That's simply neminem ledere. Number 7, we have a separate slide, and number 8, quite a long one, again in Latin. Nemo plus juris ad alium transfere potest quam ipse habet. However, it's not complicated, it's quite simple. Yeah? I am not able to transfer more rights that I possess on myself. So, for instance, this quite ancient cell phone, very old, that's my property. I'm an owner. So I can sell it, I can donate it. Yeah? This marker, that's not mine, that's the property of faculty. And being it so, I am now able to use it, but being not an owner, I'm not allowed to sell it, to donate it. Yeah? I'm not able to transfer more rights that I possess. Yeah? And because I'm not an owner, I'm not allowed to transfer the ownership. Yeah? That's just what is behind number 8. Some of these are expressly mentioned in section 3. However, some of these are not expressly mentioned in section 3. So if you will study the section 3 of our civil code, be aware that you will find a list of principles, and they are listed there in section 3. However, this list is not complete, yeah? And we know that the list is not complete, and that we have other principles, for instance, the equality of subjects. It's quite an important one, but it is not expressly mentioned in section 3. Yeah? So now in more details about the selected principles. The first one, the autonomy of will. We can also say the freedom. You are free to decide about your behavior in the scope of private law. You are free to decide if you will enter a contract or not. You are free to decide if you will enter the contract with Mr. Green or with Mr. Red. Yeah, that's your freedom. That's the area of your autonomy. You are free to decide. Yeah? You are free to decide if you will make your last will or not, perhaps. That's your area, your freedom. Yeah? However, this area of your freedom, your autonomy, has also limits. There are limits, and you can see these limits in section 1, paragraph 2 of the Civil Code. So what is limiting you in your area of freedom? Express prohibition in a statute, that's the first line. If a statute expressly prohibits something, then you are not allowed. That's the limit. And then you have other limits. Good morals, public order, the law concerning the status of persons, I will explain, the law concerning the status of persons, and including the right to protection of personality rights. Here you are not allowed to stipulate in a different way. Protection of personality rights. Yeah? For instance, the integrity of my body. Yeah? It is a value which is protected. Yeah? The integrity of my body. So if I will meet my friend and I will ask him, please be so kind and cut off my hand. It's cute today to be one-handed. He's not allowed to do this. Yeah, because my integrity, the integrity of my body is protected, and even with my consent, even if I will wish some kind of breach, some kind of intervention into my integrity, so this is a kind of intervention which I'm not allowed to agree with. Yeah? So a kind of this contract, of course, will be invalid. Yeah? To cut off my hand. Yeah? So that's the protection of personality. Yeah? For instance, the integrity of a body, of a person. Yeah? And the law concerning the status of persons. The law concerning the status of a persons. For instance, if I will enter into the contract with other party, and inside the contract there will be written that I will become a slave of the second party, that I will give up my legal personality and I will be treated like a thing. It's not possible because it's breaching the law concerning the status of person. Another example, in family law, many of these are then related with family law. For instance, you have probably heard about surrogate mothers. What is it for a situation? This situation or the institute of surrogate mothers. You have a couple, man, woman, but they are not able to have a baby. And they can ask another woman to be pregnant for them and to deliver baby for them. Yeah? In Czech Republic, I will mention it also when I will speak over next time about family law, but in general, in Czech Republic, there is a rule which will be applied to every single birth of each baby here. The mother is a woman who has given birth to the baby. The mother is that woman who has delivered the baby. Yeah? So it means the surrogate mother. She is the legal mother always. And if you try to enter into the contract between the surrogate mother and the couple who asked her to deliver the baby about a transfer of the maternity by a contract, it's not possible. It's not possible because you are breaching the law concerning the status of a person. Once a woman will deliver a baby, under Czech civil law, she is the mother. It is her status. Yeah? And it is not possible to transfer it, to move it to other person. Yeah? So just to make this example complete, it works in a Czech Republic. It works, and it works in a way that the surrogate mother, when she delivers the baby, so then the couple will adopt the child. You need adoption. Yeah, adoption is allowed. That's the Institute of Family Law, which can be used, and if it is used also concerning the surrogate motherhood, okay, yeah. But you need an adoption. You are not allowed to enter into the contract saying, okay, I will transfer my maternity to you. Yeah, that's not possible. Yeah. So this is the law concerning the status of persons, just to give you an idea what is it about here, this kind of limit. Yeah? Good morals, public order, I think it's clear. Yeah? Equal position. Equal position of subjects, not expressly mentioned in a civil code. We are in formal equal position, formally we are in equal position towards each other, and we can demonstrate this formally equal position here in this short example, let's say short case study. Let's imagine you have obtained a letter in your letterbox, and there is a kind of offer. I am offering, I don't know, a book to you, and there is written, should you not respond within 14 days that you refuse this offer, I will consider it as your consent and will send you the goods, and especially will claim the money for it. Yeah? And the question is, if you will remain silent within the period of 14 days here, if you remain silent, will the contract be entered or not? And the answer here, the answer is the contract will not be entered, even if you remain silent. Why? Because in a private law, we are equal, and nobody is allowed to impose a duty on you by his unilateral expression of will. Nobody is allowed to impose any duty on you by unilateral expression of will. So nobody is allowed even to force you to respond, to answer. Yeah? That's not allowed because we are equal formally in private law. Yeah? So you need my consent, yeah, for it. So if you take this letter, just throw it into the dustbin. It doesn't matter. The contract isn't entered because this is not allowed. Yeah. So this is about the equality of subjects in private law. And then we have more discussion on protection of a weaker, or let's say disabled or disadvantaged, or let's say vulnerable person. Yeah. We are protecting them as a, let's say, weaker party. And here you can give some examples. Who can be a disadvantaged or a weaker party, a vulnerable person? What do you think? Give some examples. Who can it be and will be protected? Yeah? In private law, we are equal formally, but in real life, it's not true. Yeah? And that's the reason why we have the principle of protection of this weaker, or let's say disadvantaged party, a vulnerable person. Give me some example. Who can be a kind? Yeah. Okay, the lease agreement is a good idea, quite a complicated one, but a good idea about a lease agreement. I have more examples here, but I will explain a lease agreement. In Czech Republic, we restrict this for the lease of a flat, for a living. Yeah? The reason. There are two possibilities how to satisfy your fundamental need to live in a kind of a structure, yeah, to have a roof over your head, and you can be happy and you can be an owner of a flat, of a house, and then you can live there, of course. But if you are not so happy and you are not an owner of a house, of a flat, the only way how to arrange your living under a kind of roof is to lease a flat or a house or a part of a house. Yeah? So this is the reason why we in Czech Republic put the lease, the lessee in case of lease of a flat, as a weaker or disadvantaged party, because otherwise he will remain under the bridge outside. Yeah? So, and that's the reason, however, why we reduce it only for a lease of a flat, for a living. Yeah? A typical example, a consumer versus an undertaker, a child or a person with a mental disorder. Yeah? These are other examples of, let's say, disadvantaged parties or vulnerable persons, and we tend to protect them. Yeah? And the last one for today, the protection of so-called good faith. Good faith in Czech legal system. Be aware that in Czech legal system we tend to understand the notion good faith in a subjective sense. Yeah? In a subjective sense, it is a state of my mind. Yeah? I'm acting legally. For instance, I'm entering into a contract, and I am convinced, that's the state of my mind, that there was no mistake, there was no problem. Yeah? Imagine you are in a shop and you are buying a new laptop or a new cell phone, something like this. There is a shop assistant. He is demonstrating the cell phone to you. There is original box. There are all the documents necessary. The guide is there and everything. And you will pay and you will obtain the cell phone. So everything seems to be perfect. However, what you don't know, and you have no reason to know it, because it wasn't possible to, from this situation, from the circumstances, it was not possible to see it. The cell phone was stolen before, which of course can affect your ownership. If a cell phone was stolen and then you was buying it, yeah? Somebody sold it to you. And because it was a situation where these circumstances were quite normal, so your state of mind was, there is no problem, everything is okay. Yeah? And so you will be somehow protected. On the other side, imagine a situation, somebody stops you suddenly on a street and offers you a car to buy, yeah? And he says, okay, I have a car behind, it's hidden there, and yes, it doesn't matter that I have no keys to give you, I have no documents, but it doesn't matter. Yes, the window is broken, fine, but it also doesn't matter, just buy it, yeah? I have a deal for you, yeah? In this situation, as a reasonable person, of course, you shall say, okay, here is a problem. I see here reasons that something is wrong here going. Yeah? the car was probably stolen, the broken window and the absence of documents and so on and so on. Yeah? So if you will buy, you will not be in good faith, you will be in a bad faith, and you will not be protected. Yeah, that's the point. However, in other legal systems, the term good faith sometimes is understood in an objective sense. Set of rules like is a good morals, honesty, decency, politeness, and so on. Yeah? In this way, if we say good faith in Czech Republic, we mean this, a state of mind. Yeah? That's the meaning in Czech Republic. However, and even in some particular sources of EU law, it is understood in this sense, yeah? A kind of rules which are behind the law, like is the good moral, honesty, decency, politeness, and so on. Yeah? So be aware of this, that in Czech Republic this means this and not this. Yeah? So it's just to explain in short. I think that for today it was quite enough for these general things like principles and the historical introduction and the historical context and consequences. I think you are quite exhausted now. So it will be enough for me. During this week or during next week, I will upload the PowerPoint. And for next time, I will prepare also a kind of a working paper for you to make groups and to work in groups, in teams, so that it's not so frontal from me just giving you information. Yeah. So it's for the next time. For today, thank you for your attendance. Have a nice day and have a nice stay in Prague as well. Good afternoon. Bye.
Good afternoon. Good afternoon, everybody. Let me welcome you at the first lecture of financial law. My name is Petr Kotáb. I'm the head tutor of this course, but by far I'm not the only one who will hold the lectures with you this semester. My colleagues from the Department of Financial Law will join me, or to be more precise, will come to back me up in the following weeks. But I will be the one who will start the course of the lectures today and also the next week. I'll be one who will finish the very last lecture in December. And last but not least, I'm the one who will administer the examination after the lectures are over. So first, a few words about how this course will go on and what is awaiting you in the end of the semester. First, as you probably know, we are facing somewhat non-standard circumstances of our lectures. The so-called hybrid autumn has been declared at the Charles University, which means that some students are present here and the other students are not present. For various reasons, they may join us in person later in the semester, or they may not join us at all, but we are lecturing for them all the same. Our lectures are therefore broadcasted or streamed to a private or semi-private channel of the law school at YouTube. And I send my greetings to the students who have joined us online today. We will also try to record our lectures and make them available for you and for everybody else offline, so that you can repeat, or perhaps if you missed some lecture, you can listen to it and watch it for the first time from the record. Nevertheless, the personal attendance of our lectures is the most recommended way towards successful completion of this course. And to this end, and to this effect, we will be following your personal attendance, which means that for every lecture there will be an attendance sheet circulated among you, and you will be asked just to put your initials next to your name in the right column of the specific lecture. So of course it's the first lecture today, the 5th of October, so please can you start and then circulate it all around. Normally, there is an attendance requirement of at least 50% of the lectures. There are 10 lectures, so you should attend at least half of them. Once again, because of the unusual circumstances of this semester, we will apply this requirement rather softly. So if you are prevented by COVID or by visa problems or by other circumstances to attend, there will be a possibility to watch the lectures offline, and the attendance requirement will be adjusted. But if you made it to Prague, and as I can see many of you have made it to Prague personally, then you are strongly recommended to attend the lectures, because the lectures will be the main source of information for you for the purposes of the examination. Unlike in some other subjects where you are given an extensive reading list, in our subject there will also be a reading list, but it's only recommended, not mandatory. So if you do not want, you don't have to read all the pieces on the reading list, which I'm going to show you in a little while. But what you should do in proper and diligent preparation for your examination is to go over the lectures, not only to attend and listen carefully, but to repeat the lectures. The presentations from the lectures will be also made available for you. So the best preparation for the examination is to go through the lectures, go through the presentations, and try to understand and remember and reflect in your bright minds what has been communicated to you. So the first piece of information I'm going to give you is the outline of the semester, how the semester will look like. As I have already mentioned, there will be 10 lectures focused on different topics of financial law. I'll be speaking about financial law in a little while, but to make you an introduction, as you can see, financial law is rather a broad subject, including perhaps several subjects that are taught separately at your home universities. So there will be a little bit of taxes, there will be a little bit of banking, a little bit of insurance. What else do we have there? Customs duties also. And that's only an abbreviation of the 2 full semesters that our Czech students have to go through and successfully pass if they want to finish the law school. So financial law is composed of tax law and then the non-tax part of financial law, of which I will be speaking in a little while. After 10 lectures are over, which will be in early December, our last lecture is on the 7th of December, then you will have some time to digest the information and to prepare for the examination, and examinations will be held as shown here. There will be 2 dates for you to choose from to come to sit for the first attempt of the examination, either before Christmas, 21st of December, or should someone prefer it, after the new year, when everything has settled, and that's 11th of January. So you are free to pick one of these 2 first dates for your examination, and then when you make your choice, you should be registered for the examination date, and the registration is done simply by an email that you will send to me. Dear Mr. Kutab, I prefer to sit for the examination on the 21st of December, full stop. 1 sentence is enough. The third date here, the 8th of January, that's the correction date, so to say. So it's not meant for the first attempt. It's here for those of you, and hopefully there will be very few of them, who will not succeed upon first attempt and who will need to re-sit for the examination. So there will be 1 date for correction. As far as the format of the examination is concerned, it will be a closed book multiple choice test. And we are still considering to hold the examination online, which may be probably reflected with some appreciation from you yourself. So I will confirm that to you before the examination, but there is a possibility, quite likely possibility, that all of the examination terms will be held online. For this purpose, we have created a team in Microsoft Teams, a team for this course, and the presentations will be placed there, and other communication will be placed there. And also the examination will take place via Microsoft Teams, if it's held online, which is very likely, as I mentioned. So one important step for you is to get access to the Microsoft Teams. Let me just try it on this machine, if it works or not. Oh, this will be too long procedure. So just to make it short, you will probably not be able to get to Microsoft Teams automatically. You will have to be granted specific individual access based on your email address. So for this purpose, again, just send me an email and I will arrange for you to have access to Microsoft Teams. So the important information for you, of course, is my email address, which I'm projecting right now. The first line is my email address. Please use it for exam registration, to get access to Microsoft Teams, and also to communicate any issues that you may have in connection with this course. This is the link to the team on Microsoft Teams. The name of the team is Financial Law 2021 Erasmus+, but as I have mentioned, you probably cannot get there before I grant you individual access based on your email addresses. So send me the email first, and then you will get access to Microsoft Teams. And you will need Microsoft Teams first to get access to the presentations of all the lectures, and also to sit for the examination if it's held online. Here is the list of the lectures. So in addition, or next to myself, there are 3 other colleagues, all of them from our department of financial law. And here is the promised reading list. As you can see, it's divided in 2 parts. The mandatory part, which consists of 1 item only, and that's presentation outlines for individual lectures. So the presentations, which will be made available to you, probably in the PDF format or maybe in the PowerPoint format. And that's the main source of your information for studying this subject. Should you be more interested in matters of financial law, and Czech tax law and Czech banking law and other parts constituting financial law, here are some additional items, pieces of information where you can get relevant information. But it's all under recommended heading, which means that it's not absolutely necessary to go through it for the purposes of the examination. It's for your benefit if you get interested in the subject. So we have a monography, a relatively brief book on Czech tax law, trying to describe in English how the Czech tax system looks like. It has been published by a colleague of ours from the Brno University, and what's important, it has been published in electronic format, and it's available online for free. So on this link you can get the text for free. And the link will be also published on Microsoft Teams, so when you get to Microsoft Teams, you will also get this document with all the links shown here. The next piece